Hello, this is Smriti Karthike, advocate, human rights lawyer in Allahabad High Court. The subject is under Women Studies, Paper 15, Module 13, Acid Attack Part 2, the stories the states tell. Here in the first slide, there is the name, there are two columns. One is the name of the state and union territories, and second is the name of the scheme. The first scheme, the state is Bihar, and the name of the scheme is Bihar Victim Compensation Scheme. Second is Goa, Goa Victim Compensation Scheme. Gujarat, Gujarat Victim Compensation Scheme. Haryana, Haryana Victim Compensation Scheme, and so on. There are. Now, the slide comes brief of the important cases of Supreme Court and High Courts. The very first case which came in the light was the case of Lakshmi. Lakshmi, an acid attack survivor from New Delhi, filed the Supreme Court PIL to control the sale of acid to ensure compensation from survivors and to guarantee access to medical care for survivors. The PIL has resulted in several groundbreaking orders regulating acid and setting minimum compensation for survivors. The petition also inspired a comprehensive Law Commission of India report. The inclusion of acid attack as specific offence in the Indian Penal Code and a law for compensation for victim survivor. All activists working on the acid attack would have to study this report and the provisions which have been quoted in the case. The facts of the cases are as follows. A young girl with big dreams, creepy, confident, beautiful, is walking to her workplace from her home, which is a mile away. As she reaches halfway, she hears her name being called out and turns to see the caller is. She sees two people on a motorbike and walks toward them. The girl on the pylon is familiar and the man riding the bike is known to her. He wanted to marry her and she had declined. As she reaches them, the girl hurls some liquid on her. She experiences excruciating pain, a burning sensation, and falls on the street. She had experienced a gruesome acid attack. Her face, her chest, and arms were burnt beyond recognition and she was in tremendous pain. It has taken many painful corrective surgeries for her to partially heal and she would never look the same again. A criminal case of attempt to murder was registered and those two persons on the bike have been convicted by a court in Delhi. When the man went in appeal to the Delhi High Court, the High Court ordered that she should be ordered a compensation of rupees 3 lakhs which has been paid to her. The battle with the law was anything but smooth. While Lakshmi had the supporter both legally and financially through her battle, the way the case panned out drew one's attention to the glaring deficiencies in the law. The first shock came when Naeem Khan, who was one of the main person in the attack, easily got bail from the court. It was then that it became clear that as long as acid attack is not classified as a separate offence, person attacking with acid would easily take bail as the judge hearing the application for the bail would not be aware of the gruesome nature of the crime. The easy availability of acid and the huge cost associated with the corrective surgeries that become necessary are either huge problems that a victim faces. In 2016, Lakshmi, with the help of her parents, her father's employee Shireen, who has fully paid for the treatment of Lakshmi, and with her lawyer, she filed a case in Supreme Court of India. There are some of the international law in comparison with Indian law. Acid attack have been reported in every region of world, with particularly high incidence in South Asia and in South Asian communities. Most states punish acid violence under the existing norms prescribed for violence crime or gender-based crime. For example, attempted murder, assault, domestic violence. The most of the countries in which this type of crimes are higher in rates are Afghanistan, Pakistan, Uganda, Cambodia and Bangladesh. In our international law, if we do a comparison, then Article 51 of the Constitution of India provides the state shall endeavour to, Clause A, promote international peace and security, Clause C, to foster respect for international law and treaty obligations in the dealing of organized people with one another. The Supreme Court has relied on Article 51 when affirming India's obligation under International Human Rights Convention and treaties. In Vishakha versus State of Rajasthan, the Supreme Court held it is now an accepted rule of judicial construction that regard must be had to international conventions and norms constructing domestic law when there is no inconsistency between them and there is a void in the domestic law. The most useful human rights conventions and treaties for activists, advocates and survivors working on acid attack are 1. ICCPR, that is International Covenant on Civil and Political Rights, ratified by India in 1968. Second, ICE-SCR, that is International Covenant on Economic, Cultural and Social Rights, ratified by India in 1968. CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, ratified by India in 1993. Specific facts in the case may also invoke the fundamental rights protections enriched in the following conventions. Conventions and treaties. CERD, Convention on the Elimination of Racial Discrimination, ratified by India in 1968. CRC, Convention on the Rights of the Child, ratified by India in 1992. Finally, an acid attack survivor's injuries may result in a disability and trigger the protection in the CRPD, that is, Convention for the Rights of the Person with Disabilities, which was ratified by India in 2007. Now, these human rights conventions provide wide protections and guarantees across a spectrum of fundamental rights. This section briefly outlines treaty provisions that obligate the Government of India to take immediate steps to eliminate acid and able to ensure for survivors. The Constitution and statutory provisions which are present in India. Article 14. The state shall not deny to any person equality before the law of the equal protection of the law within the territory of India. Article 14 is not mere formal equality. It also encompasses substantive equality. This means that equality cannot simply exist on paper. The state has to take positive actions, including taking special measures to ensure equality. As a woman in India are disappropriately the victims of acid attack, the acid attacks largely constitute generated violence. Women require special protection from acid attack under the law. Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. The Supreme Court in criteria of judgment Francis Corley Mullin versus Union Territory of Delhi and others has recognized that the right to life includes to free from inhuman and degrading treatment. Section 320 of IPC clears grievous hurt. Acid attacks are considered grievous hurt as any permanent disfigurement, disability or destruction of a body part is included in this section. Section 325. The punishment for voluntary causing grievous hurt is maximum of 7 years. Section 326. Voluntary causing grievous hurt through a dangerous weapon or other means a coercive substance is specified as being a dangerous means. Hence, acid attack will be covered. The punishment under this section is for a maximum period of life imprisonment or a period up to 10 years. There is no minimum punishment prescribed. The amendment came in 2013 in the Criminal Law of India. It says the Criminal Law Amendment Act 2013, and there are some of the following changes, like Section 100. When the right to private defense of the body extends to causing death, an act of throwing acid or administering acid, or an attempt to throw or administer acid which reasonably causes the apprehension that grievous hurt will be the consequence of such an attack. Section 326A. Whoever causes permanent or partial damage, deformity, burns, maims, disfigures or disable any parts of the body of a person with the intention or knowingly that it is likely to cause such injury or hurt shall be punished with either simple or rigorous imprisonment for a term of at least 10 years, which may extend to imprisonment for life, and a fine. The fine shall be paid to the victim and shall be just and reasonable to meet the medical expenses of the victim. Section 326B. This section says the attempt to throw or administer acid with the intention of causing permanent or partial damage, causing deformity, burns, maims, disfigures, disable, damage, grievous hurt shall be imprisoned with either simple or rigorous imprisonment for at least 5 years, up to 7 years, and a fine. Section 166A. A public servant who refuses to record any information in relation to an offence under Section 326A and 326B, as well as some other sections, shall be imprisoned and rigorous imprisonment for a term of at least 6 months, which may be extended up to 2 years, and be liable to pay a fine. This particular section is for the police persons or the personals who deny to write or to lodge an FIR. Section 166B. Whoever is in charge of any hospital, whether public or private, run by the central or state government, a local body or any person, and who contravenes Section 357A of the Code of Criminal Procedure shall be imprisoned for a term which may be extended up to 1 year with fine or both. Section 357A governs payment of fines to victim of crimes. This particular section is for the hospitals who deny the proper care or medical care of the acid attack survivor or a victim. Now, the Code of Criminal Procedure was similarly amended by the same Criminal Law Amendment Act 2013. Section 154. When the information is given by the woman victim of a crime under Section 326A, 326B, which the sections dealing with acid attack and other sections of the IPC, the information will be recorded by the police officer or any woman officer. Amendments. Section 154A provides for special provision for the survivors of offences under Section 354, 354A, 354B, 354C, 376, 376A, 376B, 376C, 376D and 376E, or Section 509 of the IPC, which includes sexual harassment, criminal force to a woman with intent to disrobe, watching a woman in a private act, stalking rape and aggravated rape. When an offence under the section has been committed and the victim has been permanently or temporarily, mentally or physically disabled, then the police officer shall, in the presence of a special educator or interpreter, record information from the victim of the victim's residence, of any place of the victim's choosing. The recording of such information may be videographed if needed. Amendments. Section 154A seems to have overlooked acid attack victims as Section 326A and 326B have not been included. This might be particularly problematic as in most cases acid attack victims suffer from significant physical disability following the attack. Section 164(5)(a) Clause A makes similar provision as 154(a) for a judicial magistrate to record the statement taking the assistance of a special educator or interpreter in cases wherein the victim is temporarily or permanently mentally or physically disabled and for the statement to be videographed. This statement shall be considered in lieu of examination in chief under the Indian Evidence Act. Here are some of the important cases which have been taken place in Allahabad High Court. First is the public interest litigation in the name of Ayushi Dubey and others versus State of UP and others. This is a case of an acid attack survivor of district Jaunpur. She was merely 18 years old and one boy wanted to marry her. At the moment, she declined that she cannot marry her, and while she was sleeping in a house, in a mud house, at around 12 a.m. in the night or in the morning, the accused threw the acid through the window pane which was open, and the victim was completely burnt and faced several injuries on her face, neck and breast. When the medical examination has been taken place, the injury was more than 55%. The case has been taken place and filed in the Allahabad High Court, and 3 lakh compensation has been granted to the victim, followed with the free medical treatment. The second public interest litigation which was filed in Allahabad High Court related with acid attack was Chirag Sahyog Sansthan versus Union of India and others. This petition was filed in the year 2013 after the verdict of Lakshmi case. In this case, the petitioners were praying to stop the sale of acid in public markets. And the petition has, after this petition and government order has came in Allahabad as well as in state of Uttar Pradesh in the year 2014 for stopping the sale of the acids. The next petition which was filed was Anshika Singh and others versus Union of India and others. It's a plight of 2 sisters who got brutally injured along with 3 years boy. The main victim was died on the very second day of the acid attack. The second sister of the deceased was burnt with 35% burn, and the 3 years old minor son has got 10% of burnt injuries. 5 lakh each compensation was granted to all the victims after filing the case in the Allahabad High Court, as well as a landmark judgment has came in this particular case because in King George Medical College 25 beds were reserved in Uttar Pradesh only for the acid attack victims. Now, after reading with the module, we have came into the conclusion. The conclusion of the module is the cumulative conclusion, and the entire picture that emerges is that a drastic initiative is required to combat the growing menace of acid attack, which is a heinous tool of the worst kind of chauvinistic society where the ideas and the actions are controlled by the attitude of male domination. It is the need of the hour that following measures may be suggested to the legislature and the administration to reduce, restrict and curb this gender bias attacks. It is required that special tribunals be created which may function as special court for the expeditious and speedy disposal of acid attack cases. It is required that a required amendment be made so that the judges hearing the acid attack matter should preferably be women and should be specially trained and sensitized. Special public prosecutor is appointed to assist the prosecution to render justice to the victim. The special contingency fund and corpus be created to help the family of the acid victims who dies as well as the survivors. It should be suggested that a suitable amendment should be made in the legislation to ensure that bail is not granted to the offenders, thus making the provisions more stringent. That legislature to be suggested to bring an amendment that anticipatory bail should not given to the acid offenders even if the provision of the anticipatory bail is introduced by the state legislature. Thank you.